elements of validity of an agreement. Yeah, this will sound, I think, maybe some will see it very simple, but actually it's not very simple. Yeah, but it's not very complicated also. Yeah, the talk about elements of validity of an agreement. Talking about the validity of an agreement, we will always refer to the 1320 of Indonesia Civil Code. I think we have several times discussed this. So if you read the 1320 of ICC, there are 4 elements of validity of an agreement. The first is there must be consent. There must be consent, or there must be an agreement of the individuals or of the parties who are bound thereby. Ya, sepakat mereka yang mengikatkan dirinya. And after the first element, the second element will be there must be a capacity to conclude an agreement. Kecakapan. Ya. There must be a capacity. So these 2 elements, the first 2 elements, if you look into it, it's related to the persons making the promise. Yeah. So consent and capacity are referring to consent given by the person and capacity of the person. Yeah. So that's why it is called as subjective. So there are subjective requirements and there are objective requirements in the validity of an agreement. Yeah, the subjective is the first 2 because it's related to the persons, immediately related to the persons. Yeah, the persons giving the consent or giving the agreement, the persons must have the capacity to do it. Yeah. And then the third element is there must be a specific subject or object, I think. This should be object. Specific object. There must be specific object, suatu hal tertentu. Ya. And there must be an admissible cause, suatu kausa yang halal. So the third and the fourth points are not related to the persons making the agreement. They are related to the object of an agreement. Yeah. So the object must be definite, must be clear, must be specific, and there must be an admissible cause. So the contents of an agreement must be legitimate, yeah, must be admissible legally. So the third and the fourth elements are called as objective requirements. So subjective and then objective. Okay, we will go one by one. There must be consent of the individuals who are bound thereby. Consent means that the 2 parties who make an agreement must agree on the matters of the agreement. Yes. Talking about consent only, it seems that the lawmaker, the maker of ICC, is really concerned about whether or not a consent is already reached by the parties. Yeah, because if you look in here, the agreement must not contain elements of error, coercion, or fraud. The error occurs regarding the subject and or the object. Coercion occurs when the parties agree to the agreement due to a threat. Fraud occurs if one of the parties intentionally gives incorrect statements accompanied by deceit. So these exceptions are all related to the first element only, actually. Yeah, because when we talk about the second element, the capacity, and then we talk about the objective requirements, they have made some stipulations related to that elements. Yeah, but talking about the consent, these are the exemptions. So let me see in here. Okay. We don't talk much about it, yeah, but I will, you can look in here. So the 1320, that is the basic clause for the validity of the agreement, yeah, but the exemptions are stipulated in 1321. Yeah, you can look now to understand. So the 1321, tiada sepakat yang sah apabila sepakat itu diberikan karena kekilafan, error, ya, or mistake, atau diperolehnya dengan paksaan atau penipuan. Then in 1320, they explain the meaning of error. Yeah, in 1323 they explain the meaning of coercion, paksaan. And still in 1324, 1325, yeah, and not including as coercion in 1326, and even fraud, 1328, yeah. I think error, coercion, yeah, these are interesting, yeah. So 1328, you can look in there about fraud. Now fraud is considered, there is a fraud in civil transaction. I mean, not in civil transactions widely, but in fraud, there is a fraud in a making of an agreement. Because when we are talking about the first element like this, the consent is the first element of validity of an agreement. So it means that the defect of the consent will be the defect of an agreement, or we can say that agreement will be defective if the consent is defective. Yeah. So consent is made, or is, what is it? Yeah. Is begun with kehendak, yeah, with the will, yeah. So there should be a will for the person, and then to give him his consent, yeah. There must be a will first. Will is a kehendak, yeah. So if the consent is defective, we can also say that the will is defective, yeah. There is cacat kehendak. Yeah, there is a defective will. So now the will, how to prove that there are meeting of minds, meeting of wills between the parties? Well, there are so many theories, yeah. You can look into the J. Satrio's book. Yeah, we don't discuss it today, of course, yeah, because we don't have time for it. And sometimes it's important to understand, sometimes it's not, yeah, because in practice we don't really look into those theories, yeah, unless there are disputes, yeah. But it's good to know, yeah. So you can look into the book by the J. Satrio, ya, Hukum Perikatan yang lahir dari Perjanjian, buku 1. He explains, yeah, very detailed about coercion, about fraud, about error, yeah, and then also the theories of the commencement of an agreement. Yeah, there is a statement theory, there is a delivery theory, there is a knowledge theory, there is a pit laws theory, there is admissions theory. Yeah, so many theories. We don't talk about it, of course, but there are theories to determine when the agreement is recent or when the agreement is reached between the parties. Yeah. Even though maybe it is not very often it is disputed between the parties, yeah, but you will look today, the cases that I will share, one case, yeah, the case that I will share is about offer and acceptance, actually, yeah, about whether or not the agreement is already binding between the parties. So the case will not talk about error, coercion, or fraud, yeah, because that will imply that the consent is reached but defective consent, yeah. But the case that we are going to discuss is that there was no consent at all, yeah, because they are still giving over an acceptance, and then the other party is counter over and so forth, yeah. And the conclusion is the agreement hasn't been reached, yeah. In the case, well, it's interesting to discuss the case, okay, but let's go back now again. So consent, yeah, means that the two parties who make an agreement must agree on the matters of the agreement. Okay? The last item that I talked is about fraud, yeah. Fraud can be considered as criminal, right? There is a criminal provision for the fraud, and also in the formation of contract. There can be a fraud if there is a defective will, yeah. So fraud can be seen in the civil perspective based on the agreement, but can be seen also in the criminal perspective, yeah. Both can happen, actually. You can under the ICC, these exemptions, you can file a cancellation of an agreement, because these elements show that there is a defective of the subject. Yeah? There is a subject requirements that is defective. And also, if you look or go through the unlawful act due to fraud, yeah, but different kind of fraud, means like fraud that is not related to the formation of contract, yeah, because this fraud is related to the formation of contract. But of course, one can be deceived without any agreement at all, right? If there is no agreement in the fraud, there goes on the part of unlawful act 1365, yeah. But this fraud is only related to the formation of contract, yeah. So this fraud will relate to an agreement between the parties, and one of the parties can state that if there is no fraud, I will never sign this agreement, yeah. So because there was a fraud, I signed this agreement, yeah. But if I knew that there was a fraud, of course, I will never sign this agreement, yeah. Okay, so the discussion on the error, coercion, fraud, yeah, is quite long, actually, and it's not only between 1321 and 1328 in here, yeah, because as I will explain, if the subjective requirements are lacking, it means that the agreement can be cancelled. Yeah. If the agreement can be cancelled, there is also another stipulations in the ICC that you should look at to understand the concept of this. It's tentang kebatalan dan pembatalan perikatan-perikatan. Yeah. You can look from 1446, yeah, and 1456. That's how to cancel the agreement based on these elements. Yeah. That in that part they will regulate about the expiry period. Yeah. Whether or not you can claim costs, expenses, and interest. Yeah. Because when we are talking about breach of contract, the compensation will refer only to the cost, expenses, and interest. Biaya rugi bunga, yeah. But when you file a claim based on unlawful act, the compensation can be material compensation, which can be calculated and can be proven, but can be also immaterial compensation, yeah, which cannot be calculated, yeah, like stressed out or defamation or maybe psychological disturbance and everything. So two different concepts, two different legal consequences. But the fraud we are talking about here is the fraud in the formation of an agreement. Yeah, so these three elements: error, coercion, and fraud. And in later time, and it is still developing, I think, yeah, because the judges are also still learning, I think, getting used to that concept, even though it's been discussed quite long. There is also penyalahgunaan keadaan, ya. I don't know how, maybe duress, ya. The English translation of penyalahgunaan keadaan, ya. Penyalahgunaan keadaan is also related to the formation of contract. It is not regulated in the ICC. Yeah, I heard that in the new ICC in the Netherlands, they already regulate that. Yeah, but Indonesia it's not there yet. But under the doctrine and also jurisprudence in Indonesia itself, even though it's not so many, yeah, perhaps. Well, I saw 3 to 4, I think, course decision related to the penyalahgunaan keadaan. So penyalahgunaan keadaan is also related to the formation of contract. Yeah, it's considered as defective will. Yeah, I think it's a mixture. The penyalahgunaan keadaan is a mixture concept between the coercion. There is a coercion or force by one party to the other party, and with the unscaled balance, yeah, or unbalanced position. So one is very strong, one is very weak, yeah, and then the strong party uses his position to force and also to influence the weaker party to enter into a contract. So that is the penyalahgunaan keadaan. Yeah. That is also related to the formation of contract. Yeah. So there are actually 4 elements now. The 3 elements are written in the ICC. The 4th is the penyalahgunaan keadaan. It's still being discussed. Yeah. Some decisions are still, I think, confused, perhaps. Yeah. Because some say that penyalahgunaan keadaan is an unlawful act, yeah. But some say that penyalahgunaan keadaan is a breach of formation of contract, yeah. So I think the legal world in Indonesia is still learning on that concept, but it's becoming clear and clear, yeah. But again, when we are talking about these exemptions, yeah, when it is applied in the claim. Let's say that one party claims the other party did some fraud to an agreement. Yeah. Well, it's not easy to prove. Yeah, I think it's very hard to prove. Yeah. How to prove that there was a fraud? Yeah. If there is a substantial fact that is very clear that what has been promised is very different than what has been delivered, I think perhaps there is a case, yeah, and it's not very hard. But if this fraud is only related to the this promise, that promise, yeah, before entering into an agreement, they say this, they promise this, but then after we enter the agreement, nothing happens at all. Yeah. So those, I think, is very hard to prove. Yeah. And there are also exceptions. Yeah, because for this kind of thing, there is an expiry period. I think we are going to discuss it in the next slide. Okay, so consent. Yeah, consent. Just the first element. So many discussions, so many theories. Yeah, like I said, J. Satrio has several theories on that. When there is a consent, yeah, he has explained so many theories. You can read it in his book, yeah. But the consent can be defective, yeah. So the first is whether there is a consent, yeah, and then the second is if there is a consent, whether the consent of the parties is defective or not defective. Cacat kehendak terjadi atau tidak, ya. Whether there is an error, coercion, fraud, or penyalahgunaan keadaan. So interesting, yeah. If there is a defective consent, then the agreement can be cancelled. Okay, we're talking on the first element. Now we are talking on the second element. The second element is the capacity. Yeah, the capacity refers to whether you are entitled to represent yourself to enter into an agreement. Yeah. So the first rule of thumb is whether you are mature or not. Yeah. The person who makes an agreement must be capable according to the law. Basically, everyone who is mature and healthy of mind is capable according to the law. Ya. Setiap orang adalah cakap untuk membuat perikatan jika ia oleh undang-undang tidak dinyatakan tak cakap. Ya. So everybody can make an agreement, right? Unless he's declared as not in his capacity. Nah, tak cakap untuk membuat suatu perjanjian is under 13, ya. Orang-orang yang belum dewasa, immature. Mereka yang ditaruh di bawah pengampuan. Pengampuan is like maybe you are crazy, yeah. Maybe you are very stressed. Maybe you are mentally ill, yeah. You cannot do legal action by yourself, so there has to be a pengampu, yeah. And then the third is women, yeah. But now the third element, since 1974, the marriage law, we can see in the marriage law that setiap pria dan wanita secara sama-sama mempunyai kedudukan hukum yang sama, kan? Mempunyai kedudukan hukum yang sama, setiap pria dan wanita, ya. So every man and woman. So the third element is no longer relevant to be discussed, yeah. So either you are immature or you are placed under the pengampuan. Or also, yeah, if you are immature, of course there should be a caretaker, kan?
there should be a wali, caretaker, representative to take care of your interests. If you are a teenager, for example, there should be a caretaker, representative that can act on behalf of this teenager. That's for the immature. But there is also an exemption, of course, and still under marriage law. I forgot the marriage law is 18, 16, right? That can get married, but if they get married less than 18, then they will be considered adult also. The 1330 ICC is also related to the 330. Belum dewasa, okay. So how old will that be? Belum dewasa adalah mereka yang belum mencapai umur genap 21 tahun. So if you are asking who is considered adult, reaching 21 years old, dan tidak lebih dahulu telah kawin, okay. Unless you are married, you will be considered an adult. Apabila perkawinan itu dibubarkan sebelum umur mereka genap 21 tahun, maka mereka tidak kembali lagi dalam kedudukan belum dewasa. Mereka yang belum dewasa dan tidak berada di bawah kekuasaan orang tua, berada di bawah perwalian atas dasar dan dengan cara sebagaimana teratur. Oke, 25 ada pengaturannya. Yang berperaturan dan bilang segala keraguan. Okay. So those are the things on the capacity. Capacity is also determined by law. For example, if the company law, it is determined that the board of the company is the subject authorized to represent the company. No, this is not capacity actually. Wait. This is not a capacity. Okay. I want to explain about capacity is different than authority. So capacity, if you are not, for example, in the company law, of course, company is a legal entity, and legal entity cannot represent itself, right? So that's why there must be a person representing the legal entity. And this person representing a legal entity is based on the law, yes. Who can represent the legal entity? The law said it's the directors, right? The directors. So any directors, unless stipulated otherwise in the Articles of Association, can represent a company. When we are talking about capacity is talking about whether you are allowed to enter into an agreement, legally speaking. So whether you are mature already and you are not placed in any pengampuan, in any authority, in any other authority, that's the capacity. But when we are talking about authority, representing a company, we are not talking specifically about the capacity, because the capacity will be taken for granted. Of course, the director will already be a mature person and also not di bawah pengampuan. That's of course the understanding. But we have to make sure whether you are allowed to represent the company. So that's about authority. So this is talking about whether you are doing something within your authority or you are doing something outside your authority. That's why we understand the principle of intra vires and ultra vires, right? Intra vires, if you are doing actions according to the stipulated conditions. Ultra vires, which means that you are doing something outside your
authority. And the legal consequence of the ultra vires is a null and void. Yeah. Because since you are not authorized to do it, any of your actions will be considered null and void. Now, this is of course not that simple, I think. Yeah. Well, the law is simple. Yeah. For example, like, I don't know whether you have studied company law or not, yeah, but you will find if you study the company law, there is a provision under the company law that when the director gives power of attorney to someone, the power of attorney should be made in writing and should be made on specific matters only. So writing and specific matters only. That is considered as power of attorney, ya, surat kuasa. Power of attorney is surat kuasa, ya. That will be considered as power of attorney as long as it is made in writing and for the specific matter only, not for the general matters. Yeah. Now this is related, that clause is related to the provision under ICC, because ICC stipulates that a power of attorney can be made for general matters and for specific matters. Now, the question that we have is, if this guy, yeah, saying that he is authorized to do the actions, but doesn't have any power of attorney, yeah, but this guy signs an agreement representing the company, but doesn't have any power of attorney, how we see his action then? Yeah. Would he be not in capacity? If we are talking on the second element, the capacity is not talking about the authority actually, yeah, but the capacity to do the legal action. That person, as long as he is mature and he doesn't have any pengampuan, he's fine, legally speaking, right? But if he doesn't have any power of attorney, it means that he doesn't have any authority to represent someone else, right? Because the power of attorney can be given to anyone outside the company at all, right? If you give a power of attorney to someone, it can be your family, it can be your outside family, it can be your friend, it can be anyone, right? Now imagine there is a third party outside the company, nobody knows it, but then signing an agreement on behalf of the company without any power of attorney. Yeah. How can we see that? Yeah. I think it's not about the capacity. Yeah. The capacity is there, but it is about the authority. Yeah. He doesn't have any authority to represent the company. So it would mean that the agreement will be considered as null and void. Of course, unless the company itself acknowledges it as binding to him, yeah, as binding to the company. I think there might be a overlap concept, yeah, between person without authority doing something with the zakwarneming, yeah. Do you remember about zakwarneming concept? It's a perbuatan menurut hukum. It's not unlawful act, but it's a lawful act, yeah. And the source comes not from an agreement, yeah, but from the law. So the zakwarneming, in good faith, there can be someone who acts on behalf of other person, right? Without any agreement, yeah, without any power of attorney also. But this guy acts for the best interest of the other person because perhaps the other person is not capable of doing it right now. Perhaps
the other person is staying outside Indonesia, for example, and he cannot do this, he cannot do that. So this guy, the guy doing zakwarneming is representing this person outside country. So that can also be considered as zakwarneming, perbuatan menurut hukum. Yeah, it's not unlawful act. Yeah, even though there is no agreement, there is no power of attorney, as long as the person representing the interests of others are doing in good faith for the best interest of the other party, it's fine also. Yeah. So can you see the overlap? Yeah. One is without power of attorney. The zakwarneming is also without the power of attorney. But I think the difference is one is acting in good faith, yeah, for the best interests of the other party, while one may not be doing in the best interest. Yeah. But that's why it will be different case by case. Yeah. So what I mean is, even though the company law very clearly say that if you don't have a power of attorney, I mean, if you are giving someone a proxy or power of attorney, it must be in writing and it must be on a specific matter only. Now, this power of attorney is not there. Whether or not this agreement binds the company. Well, we have to look whether this guy doing and bringing the company's name without authority is acting in good faith or not. I think, yeah, that is the overlap between zakwarneming and doing actions without power of attorney. So it's not automatic that every action made without power of attorney will be null and void. Yeah, that's the ultra vires concept. Yeah, if you do something outside your authority, of course it is considered null and void. It is considered as ultra vires, beyond your authority. You are not allowed to do it. Null and void. There is an interesting concept related to the ultra vires that I want to share. It's very interesting, but I think it's also important to understand. Yeah, you will learn about arbitration law. Yeah, arbitration law is when the parties refer to the arbitration board to settle the disputes. Yeah, it is based on the arbitration agreement. Yeah, it is based on the arbitration agreement. So there will be no arbitration without an agreement. Yeah, there is the difference between the arbitration and the court proceeding. Yeah, if you want to arbitrate, not going to the court, you have to agree it in writing through an agreement. Now, in some case in Indonesia, it happens that the parties agree to arbitrate, yeah, so they go to arbitration. But then there is no agreement in the arbitration agreement that the arbitrators, the panel of arbitrators, can decide based on justice. Yeah, if you remember, if you look into the claim by the lawyer, they will have the demands, right? The first, second, third, fourth, fifth, sixth demands, yeah. And or else ex aequo et bono, right? Berdasarkan kepatutan dan keadilan, ya. So that is, if you don't agree with my demands, just do what you like to do. That's basically what the lawyer says, yeah. Now, if the claim says ex aequo et bono, and the other party, the defendant or the counterparty, also states the same, these are my demands,
or else ex aequo bono, it would mean that the parties agree that the panel of arbitrators can decide based on law or based on justice. Yeah. So the parties give freedom to the arbitrators. Now, I don't really understand the detail of the case, but it appears that in this case, in this arbitration case, there is no such agreement that ex aequo bono is there. There is no agreement between the parties that they agree that the decisions can be granted based on justice. And then what happens? What happens is the arbitrators decided the case based on justice, not based on law. And then the case was disputed. We're talking about decision is final and binding, right? Because arbitration is final and binding. It's only one stage, not like the court, there is a high court, there is a Supreme Court. Arbitration is not. Once it's decided, it's final and binding. And then one of the parties file a claim to cancel the decision, the arbitration decision. And I don't know what are the claims, yeah, but one of the considerations of the judges to cancel the arbitration decision is because the judges, the panel of arbitrators are acting outside their authority, are acting ultra vires, actually, are acting outside their authority. So, like I said, arbitration when the parties go to the arbitration, it must be based on arbitration agreement. If there is none, nobody can go to arbitration. Yeah? And then the parties can agree whether they want this case decided based on law or both. Yeah, can be either or. Yeah. So when the parties did not give that authority to these arbitrators, and then the arbitrators acted on that position, it will be considered as ultra vires. So this is similar. Yeah. So the capacity is different than authority. Yeah. Can we say that the panel of arbitrators is not in their capacity to decide? If capacity is interpreted as authority, yes, we can, yeah. But the capacity in the agreement is different. Yeah. But what is more correct, I think, is that we can say that the arbitrators is not in their authority to decide that, or they are acting outside or beyond what they are authorized to do, right? So now it is canceled, the arbitration decision. Can you imagine? And it is outside the elements of cancellation, the arbitration decision, actually. Okay, this is just for you to know about the ultra vires. Yeah. Of course, if you agree on something, there should be an object, right? If there is no object, then what's to be done? Yeah, what's to be agreed? This element means what is promised, the rights and obligation of both parties. Yeah. The specific object will relate heavily to the rights and obligations between the parties. The good referred to in the agreement shall at least be determined of their type. Ya. At least tipenya, jenisnya itu apa gitu ya. If you are not able to clearly define it now, ya, at least the type we should agree first. The amount does not need to be mentioned as long as it can, yeah, that's the amount, maksudnya jumlahnya berapa ya, as it can be calculated or determined. For example, an agreement on the harvest of tobacco from a farm in the coming year is valid. Jadi kan dia mau
panen ya, panen tembakau. But an agreement to sell and purchase a tea for 100 using no clear and further explanation should be considered insufficiently clear. Yeah, okay. We don't need to argue whether the first example is better than the second example. I think, of course, when we make an agreement, of course, we should be clear. And in a sell and purchase, for example, it should be clear the thing that we want to buy, yeah, and it should be clear also the price of it, yeah. When we take something that we want to buy and we understand the price, so that's the object, right? That's the specific object. It's clear, yeah. But if we don't do very clearly, of course, it will create fuzziness, yeah, uncertainty, yeah, and confusion, of course, between the parties. Which good to be delivered, yeah, because it's not clear what do you want to buy, for example, or what do I have to give to you. Yeah, it's not clear. So you can see it here. It's still around 1320, yeah. 1332 you see hanya barang-barang yang dapat diperdagangkan saja dapat menjadi pokok perjanjian, ya, of course, ya. We cannot sell the road, right? We cannot sell the public road, yeah, because it's owned by the government, right? We cannot sell the beach, for example. Yeah, you cannot own it, you cannot sell it, right? Yeah, maybe you can manage it, yeah. If you build a hotel and then you manage the beach, yeah, perhaps that is your obligation, yeah, because you build a hotel around it, but you don't own it, yeah. If you don't own it, then you cannot sell it, right? So hanya barang-barang yang dapat diperdagangkan saja dapat menjadi pokok perjanjian. The same applies to a legal thing, yeah, just like drugs, narcotics. You cannot do it on commercial. So it's not considered as barang yang dapat diperdagangkan. Suatu perjanjian harus mempunyai sebagai pokok suatu barang yang paling sedikit ditentukan jenisnya, ya, at least the type of it, ya. Tidaklah menjadi halangan bahwa jumlah barang tidak tentu, asal saja jumlah itu kemudian dapat ditentukan atau dihitung, ya, oke. We agree on the type, then we later can calculate, ya. And also barang-barang yang baru akan ada di kemudian hari dapat menjadi pokok suatu perjanjian. This is interesting, right? Yeah, if you that's why the loan agreement for the construction of building is fine, because the loan will cover the pledge for the land, the mortgage, yeah, the mortgage for the land, including the building that is still constructed, yeah. So as long as the building is being constructed step by step until it is completed, the mortgage will will include everything, the land and the building, even though it is constructed in gradual. Okay, so there must be a specific object, the third element. Now the fourth element. The fourth element, I think we touched it briefly last week, right? When we are talking about freedom of contract principle, there is a limitation of freedom of contract principle and admissible cause. Even though it is not very clear under the freedom of contract principle, but the freedom of contract principle always refers to this clause. Okay, so this is very famous actually. If you look in here, ya, suatu perjanjian tanpa sebab atau yang telah dibuat karena suatu sebab yang palsu atau terlarang tidak mempunyai kekuatan. Ya, tidak mempunyai kekuatan is considered as null and void, ya, is interpreted as null and void.
Jika tidak dinyatakan suatu sebab, tetapi ada suatu sebab yang halal, ataupun jika ada suatu sebab yang lain daripada yang dinyatakan perjanjian, namun demikian adalah sah. Now, 1337 is mostly referred to when the parties claim against the freedom of contract principle. So 1335 and 1337 ya. 1337 suatu sebab adalah terlarang apabila dilarang oleh undang-undang. An agreement prohibited by law is the sale and purchase of drugs. Yeah, it is prohibited by law. So the cause is forbidden. Yeah, you cannot. It's null and void. Yeah, you don't need to go to the court to request for a decision that this is null and void. Yeah, it doesn't make any sense, right? Even though it's okay, I mean, it doesn't hurt to do that, but I don't think it's logical. If it is null and void because it is against the law, well, of course, it should be considered as null and void without any involvement of the court. If it is null and void, it is as if there was no agreement, right? So why do I need to go to the court to request the judge there was no agreement? Well, if there is no agreement, there was no agreement, right? If there is no agreement, there should be in the past time no agreement at all. So null and void, right? But I think some still go to the court, yeah, because in the reality there can be a dispute about this thing. Yeah, one party says this is null and void contract. The other party says this is not null and void. Everything is still binding. Yeah, perhaps only one clause. Well, if we are talking about the cause, and the cause is against the law, of course, the whole agreement is null and void. Yeah. So this is different. I think I also discussed about consumer protection law before, right? The consumer protection law only considered the illegitimate clause. When the clause is against the consumer protection law, the clause is null and void. Yeah. So the consumer protection law is not talking about the cause of the agreement. But this 1335 and 1337 is talking about the cause, the intents of the agreements. The Professor Subekti mentions that when we are talking about the cause, we are talking about the contents of an agreement. What are the contents of the agreement? Are the contents against the law or not? Yeah. I'll look it as the intent. Yeah, if the intents of the parties entering into agreement is violating the law, of course it is null and void. Yeah. Atau apabila berlawanan dengan kesusilaan baik. Yeah, in here is a sexual service agreement. Violates public order is the use of debt collector services. Yeah, depends on how the debt collector is doing it, right? If it is doing it politely, I think it's important thing, yeah. But if it is doing like, well, do many bad things, many threats, yeah, of course, yeah, it is not good for the public order, because it's as if they are becoming some sort of a police or some sort of official instance having a authority to do pressures, right? So those are the four elements, yeah. The consent, the capacity, the subject matter or the object of the transaction, and also the admissible cause, yeah. Well, in practice, there will be many variations, yeah. The 1335, 1337 will have also many variations. So subjective and objective, yeah. If these elements are not fulfilled, either party has the right to request that the agreement be cancelled. So not null and void, yeah. The defect is on the consent and on the capacity, yeah. As long as the parties are fine, go ahead. We don't need to cancel anything. But as long as one party is not fine, of course, they can't cancel it. The party who can request the cancellation is the incompetent party or the party who gives the agreement non-freely. Yeah, coerced or defrauded, yeah, because of the fraud. An objective, if the elements are not fulfilled, the agreement will be null and void. Yeah, that's the object and the admissible cause. That is, from the beginning, there was never an agreement and there was never an obligation. Yeah. So you understand, yeah, the cancellation happens on the time it is cancelled. The previous events are there, were acknowledged as being happened, right? But when you are saying this is null and void, it is as if it's never arise. It's never been born at all, right? For example, like there is a regulation. The regulation was effective since 1 June until now, for example. And now, today, let's assume that there is a judge in the Supreme Court saying that that regulation is against the law, melawan undang-undang, because the Supreme Court has the authority to review the regulations below the law, right? They consider this against the law and declare that the regulation is null and void. What will happen? Of course, it will be considered, if it is null and void, it will be considered that the regulation was never been born at all, was never been enacted at all. So those obligations between June until now never happen, right? Never arises. So if there is no obligation, there will be no penalty, right? Yeah, no law at all. That's the same concept of the agreement. No agreement at all. So one is no regulation at all, so it doesn't create any obligations. The other is no agreement at all. So the same, does not create any right or obligation. Yeah. But when we are talking about cancellation, what has been done is done. Yeah, we don't argue about it anymore. But at some point, it is cancelled. Yeah, and when it is cancelled, we stop doing anything. And when it is cancelled, it can be include the cost, expenses, and interest. Yeah. So when like when I was in your position as a student, hearing this concept, yeah, about the fraud, coercion, and error, mistake, yeah, almost never find it in the practice, yeah, because it's very rare, yeah, it's very rare happening, and the case I think is quite rare. What is quite many, I think, is based on fraud. Yeah, the formation of contract is made based on fraud. But again, how to prove it is very hard. Yeah, even though we try to understand the 1328, but it's very not easy to prove it. And you can see it here. What is important related to this? Yeah. You can see in 1453, ya, dalam hal-hal yang diatur, okay, 1446, 1449, okay. So 1449, perikatan-perikatan yang dibuat dengan paksaan, kekilafan, atau penipuan, menerbitkan suatu tuntutan untuk membatalkan. So again, this is the answer of the subjective requirements. It is cancelled, not null and void, ya. Menerbitkan suatu tuntutan untuk membatalkan. So the person damaged by this defect of elements can file a claim to cancel the agreement. That will be considered as gugatan pembatalan ya, because you claim for cancellation. So this is different than perbuatan melawan hukum. Ya, it's different than 1365 ya, because 1365 tiap perbuatan melanggar hukum yang membawa kerugian mewajibkan orang karena salahnya menerbitkan kerugian itu mengganti kerugian tersebut ya. It's different, it's already regulated in here untuk membatalkan because there is an agreement, right? While 1365 is not talking about agreement. There is any unlawful act, and when that happens, I can file a claim against you. Yeah. So tuntutan untuk membatalkan is very important in here. Yeah. But in practice, I tell you, so many claims are when they want to cancel an agreement due to the fraud or coercion or anything else, they file a claim based on 1365. Yeah. Well, what happens then? Well, one or some few judges declare that it is few judges agree with the claimant that it is an unlawful act, yeah. But some, so more than few, yeah, declare that it is wrong to state to file a claim on unlawful act when there is a fraud in the formation of contract. Yeah. Because when you file a claim against the other party based on fraud on an agreement, there should be based on 1449 here. So tuntutan untuk membatalkan. Yeah. So this is in practice, yeah. So in practice, and what we see in ICC might be different. And you will look also the 1454. Yeah, this is the difference again. The other difference between unlawful act and the cancellation based on fraud. The general expiry under the ICC. Do you know how much? The general expiry period. This is important law. Many do not know, many do not care about it. If you have a claim against someone else, how long can I claim it? It's about expiry. It's 30 years, yeah. So in general, it is 30 years. You have time to file a claim. Of course, after the lapse of 30 years, you don't have any more claim. I mean, your claim is considered as relinquished. You relinquish your claim after 30 years. That's the expiry, yeah? Now, the other thing is 1454. You can see that's the other difference, ya. Dalam semua hal di mana suatu tuntutan atau pernyataan batalnya suatu perikatan tidak dibatasi dengan suatu ketentuan undang-undang khusus, waktu itu adalah 5 tahun. So, there is a limitation of 5 years. And again, what is interesting is 1456 actually ya. Tuntutan untuk pernyataan batal gugur jika orang belum dewasa, orang yang ditaruh di bawah pengampuan, perempuan yang bersuami yang bertindak tanpa bantuan suaminya, ya this is not relevant anymore. Atau orang yang dapat memajukan adanya paksaan, kekhilafan atau penipuan secara tegas, ya secara tegas kan you clearly declare it ya, or confirm or acknowledge it. Atau secara diam-diam, quietly, silently, telah menguatkan perikatannya setelah ia menjadi dewasa. Pengampuannya hapus, perkawinan bubar, paksaan berhenti, atau setelah diketahuinya tentang adanya kekhilafan atau penipuan. Nah, how to prove that there is a silent agreement? And this is important, yeah, because 1456 said
secara tegas atau secara diam-diam. Secara tegas, I think it's easier, ya. You declare it very clearly, ya. You declare it in writing, ya. But if you say it quietly or silently, how to prove it? Now, Subekti says, I think this is logical and important to understand. Subekti says that when the parties in the agreement saying that one party do the fraud, do the mistake, do the penyalahgunaan keadaan, ya, silently do the transactions. I mean, one is delivering the good and the other is paying the money, and then they still continue the cooperation, the transaction. That is considered as silent affirmation. Ya, jadi penegasan diam-diam itu kalau ternyata para pihak tetap melakukannya. Especially the party being damaged or the party being defrauded still do the performance under the agreement. That can be considered as penguatan diam-diam, ya. Silent affirmation by Subekti. So in some cases also, when the judges deal with the fraud case under the formation of contract, the judge considers that since you are doing the transaction, yeah, you still do the performance, there is no fraud. Yeah. So the 1456 Act, I think, is important because it's talking not only about the strong or definitive affirmation, but also on the silent affirmation.